Digital Personal Data Protection Rule 2025. The Government of India has notified the Digital Personal Data Protection DPDP Rule 2025, marking the complete operationalization of the DPDP Act 2023. This comes 8 years after the Supreme Court case Puttaswamy 2017 judgment that declared privacy a fundamental right. The rules seek to strengthen data protection, detail compliance mechanism, and define the roles of data fiduciaries, data principals, and the Data Protection Board of India (DPBI). Key features of the DPDP Act and the rules: citizen-centric legal architecture, सरल, simple, accessible, rational, and actionable design, uses plain language and illustration for ease of compliance. Rights and duties: data principals, citizens' right to consent, correction, erasure, grievance redressal. Data fiduciaries, entities, obligation to process data lawfully, ensure scrutiny, safeguard, and report breaches. Phased implementation timeline. Immediate provisions. DPBI operationalized with 4 members headquarters in New Delhi. Amendment to Right to Information (RTI) Act 2005 becomes effective, restricting disclosure of personal information. Delayed provision 12-18 months. Informed consent requirement. Purpose limitation in data processing. Mandatory breach notification to users. Appointment of data protection officers. Launch of consent manager framework. Full compliance for large tech firms. Data fiduciaries and significant data fiduciaries. Categories determined by volume and sensitivity of data processed. Criteria include impact on sovereignty, democracy, national security, and public order. Major global and Indian tech companies Meta, Google, Apple, Microsoft, Amazon expected to be classified as SDFs. Obligation of SDFs: higher compliance standards, data protection impact assessment, mandatory verification of parental consent for children's data, data localization and transfer rule introduced conditional data localization. The government will specify categories of personal and traffic data that cannot leave India, to be decided by a government-appointed committee. Significant pushback expected from global tech firms. Industry view. NASSCOM Data Security Council of India stresses interoperability friendly cross-border frameworks. Processing of children's data. Companies must adopt mechanism for verifiable parental consent. No government prescribed model flexibility given to firms. Behavioral tracking and targeted ads for children generally prohibited, but limited processing allowed to prevent exposure to harmful content. Breach notification and penalties. Obligation: inform impact user without delay regarding nature and extent of breach, timing and location, expected consequences, mitigation steps. Penalties: up to 250 crore for failure to prevent data breaches. Wide powers vested in DPB to investigate and penalize. Criticism of the rules: weakening the RTI Act, for example, removal of public interest override for personal information of public officials, reduces transparency. Civil society concerns. According to the Internet Freedom Foundation, rules enable exclusive data collection by state agencies and lack structural safeguard and oversight. Wide government exemptions. Concerns over state and its instrumentalities. Receiving broad exemptions may undermine privacy protection and enable unhacked data processing by state agencies. Data localization pushback. Creates compliance burden on global tech companies, may affect India's digital trade relations. Delayed implementation. Key citizen protection. Consent breach notification. Erasure right postponed by 12-18 months. Ambiguity in parental consent mechanism. Companies lack clarity on acceptable models. Risk of inconsistent approaches. Capacity constraint for DPBI. Only 4 members could be insufficient for a country with massive digital penetration. Compliance burden all on small firms. Rules may disproportionately affect startups with limited resources. Way forward: strengthen independent oversight. Ensure DPBI functions autonomously with adequate staffing and resources, clarified data localization norms, engage with industry and global partners to build interoperable transfer mechanisms, restore transparency balance, re-examine RTI-related amendments to protect citizens' right to information, provide transitional support to firms, standard templates and guidance for parental consent, breach notification and consent management, build public awareness, large-scale digital literacy campaigns on data rights and responsibility, enhance security standards, regular audit, incident response protocols, and minimum baseline cybersecurity norms. Conclusion: the DPDP Act 2023 and Rule 2025 represent a landmark step in India's journey toward a modern, comprehensive data protection regime. They ensure national security, public order, friendly relations with foreign states, and aim to create an innovation-friendly ecosystem. While they fulfill long-standing constitutional and policy commitments to individual privacy, balancing privacy, transparency, innovation, and national security remains the central challenge. Effective implementation, stakeholder consultation, and a robust oversight mechanism will be critical to realizing the full potential of India's digital privacy law.